Hello and welcome to our video on agreements. We're joined again by our director, Tumelo Mashavela, and she's going to be helping us unpack more on what agreements are in particular license agreements and the different types of license agreements that you do get. And we want to just take a moment now to recap on what in particular an agreement is. Basically, what a contract is an agreement between two parties. And what it does is, in essence, it's legally binding and it's a promise to fulfill an obligation in exchange for something of value. So you give something to another party, you get something in return. So it's a mutually beneficial exchange. So welcome, Tumelo, and thank you very much for joining us.
Thanks, Kutlwano.
All right, so now let's get into it. As you know, we previously discussed about the various types of license agreements, and Tumelo will give us a quick recap on these types of license agreements and under what circumstances an entrepreneur should consider concluding such a license agreement.
As we've posted that, there are three types of licenses, which is a sole license, an exclusive license, and a non-exclusive license. So all of these, they have pros and cons. Let's take, if we start with a non-exclusive license, it basically means that myself as a licensor, I'm now able to provide licenses to more than one party. And I always advise, clients to say, it's a give and take. For example, if you are concluding a non-exclusive license, obviously it means that there's a possibility that you will not be able to get more royalties, because if I'm a licensee, I'm going to negotiate and say, but you're already giving Kutlwano a license as well. You're already giving a company A license as well. So I don't want to pay more royalties. So the chances are, if you conclude a non-exclusive license, you might not get a much bigger royalties from your licensees. And however, the good thing is that, you are able to spread, you're actually spreading the risk, because if Tumelo is not performing, then you will be able to get royalties from other people. So normally such a license, you can conclude it if you know that there are different players within the market. There are companies that are able to use your product, more than one company. Then I would advise you to go for a non-exclusive license. The risk is actually less, because like I said, if company A is not performing, the other company might be able to perform. And an exclusive license, this one, I always say you need to be very careful, because remember, it also prohibits you from using that particular technology. So if you are certain that you don't want to use the technology, then yes, go ahead and conclude an exclusive license, and the chances are you will be able to negotiate a much higher royalty, because you are providing the other party with exclusivity, which they should be able to pay for it.
Okay.
And so,
sorry to interrupt you. Can I just make sure here? So you're saying that if I, as the owner of the intellectual property, give someone or grant someone an exclusive license, I exclude myself from using it?
Yes, you are excluded from using it, and a lot of people are not aware of it. So then we have a sole license. A sole license basically, it's an exclusive license. However, you are, as the licensor, you are able to use that technology as sole license. Okay. So, and these ones are always advised, especially universities, to say, rather enter into a sole license, where you will then have the opportunity to be able to conduct further research on your technology. Rather, unlike if you have concluded an exclusive license. So you need to just be very careful. Exclusive, if you use that technology, you are actually breaching the contract. You are not allowed to use that particular technology.
All right. So speaking of the clauses, can you also just highlight for us some of the most important terms to look out for when it comes to license agreements?
Okay, the list is endless, but I'm just going to mention a few. For example, it is very important that you define this IP that you are actually licensing to the licensee. So definition of the IP is crucial, because are you licensing only a patents, or are you actually licensing patents as well as a trade secret or a know-how? So it is very important that we define this IP that is the subject matter of that license. Secondly, another term is obviously royalties. How much are you going to be paid? And with regard to royalties, what is important is the basis on which the royalty is going to be paid or is going to be determined. Are we going to be paying royalty per product sold, or are we going to be paying royalty? It doesn't for maybe every 100 units that you have sold. So obviously it will depend on the subject of that particular IP. Another thing is that is important is territory. The license, is it only limited in South Africa, or is limited in or it extends to other countries? Another thing is ownership of improvements that are going to be made. This is very important, because when somebody commercializes your product or your IP, as they manufacture or as they commercialize, in most instances, it is possible that there will be some improvements that are going to be made on your IP. So you need to agree with the license between there has to be an agreement between the licensor and the licensee as to who gets to own these improvements. So that is important. Another thing is let me just think. I think confidentiality is important. It includes confidentiality clauses, between yourselves, and I think that's what I can think of at the moment. But there are lots of clauses that are involved on a license. On a license agreement, obviously the type of license that you're concluding, that is also very important. So at the end of the day, the rights and obligations of both parties are actually going to be important. And you also need to understand, your rights and obligations as both a licensor and a licensee. Another important one that I think I should mention is, the ability to be able to review the books of the licensee. Because remember, you are going to be sitting there as a licensor and waiting for payments from the licensee. And if you're not receiving any payments, or you feel like you are being short paid, you need to have the right to be able to review the books and check whether or not indeed what the licensee has paid you is actually what was supposed to be due to you. Another one that I'm thinking of is, who gets to be responsible for the management of the patents. If the license relates to patents, who gets to be responsible for the payment of renewal fees, for ensuring that the patents are always in force. That's what I can think of. But I mean, people will need to come to Chaya Mashabela Attorneys so that we are able to assist you in drafting a proper license agreement that protects your rights.